This is generally a good idea for life. If you must eat crow, eat that crow while it is young and tender, or surely you will eat it while it is old and tough. All right, the next story is a much, much lighter story. I love this next story, so I really hope you do too. This is in the Supreme Court of Pennsylvania, as all disciplinary counsel cases are, and this is a disciplinary action against attorney Jamie Ray Leonetti. Upon consideration and recommendation of the three-member panel, the joint petition in support of discipline is granted on consent, which means she agreed, and she is suspended from the bar of the Commonwealth of Pennsylvania for a period of 1 year and 1 day. Petitioner, the Office of Disciplinary Counsel, file this joint petition in support of discipline on consent under Pennsylvania Rule of Disciplinary Enforcement 215D. Petitioner is the Office of Disciplinary Counsel. Respondent is Jamie Ray Leonetti, born in '73. Respondent is aware of this open investigation, and in connection with that investigation, respondent submitted a letter, and she agreed to enter this joint recommendation. And she stipulates that the following factual allegations are true and correct, and that she did violate the rules of professional conduct. So all that preparation just means that she agreed to this. Like, this is not disputed. These are undisputed facts. Respondent investigated whether Ms. Cleary and Mr. Cleary, the Clearys, had a basis to pursue a particular medical malpractice claim against the Jefferson Health System, the Doylestown Women's Health Center, and 2 doctors. On February 15, 2014, respondent commenced a lawsuit on behalf of the Clearys in Philadelphia court by filing a precipice to issue a writ of summons. Really quickly, a writ of summons is a little bit different than a complaint. In Pennsylvania, you can begin a lawsuit with a writ of summons, which is literally just the summons, not even the complaint. The summons will list a cause of action, but it's just going to say, like, breach of contract or medical malpractice or something. So you can begin a complaint without filing a complaint. You can begin a lawsuit without filing a complaint by using a writ of summons, which writ is just a word that means you have a proper legal procedure that you can go through, and in this case, the procedure of the summons. The writ of summons gives you the summons. And so that begins the lawsuit. So she's now begun a lawsuit. The lawsuit was scheduled for an arbitration hearing on November 3rd, 2014. Respondent became employed as a staff attorney with the Disability Rights Network of Pennsylvania, DRN. The arbitration hearing was rescheduled by respondent. It was scheduled till January 9th, and she once again asked for a continuance on January 5th. It was continued again to March 6th. March 6th is the important date. Respondent received a notice of the new March 6th date and advised her client that the arbitration hearing was rescheduled to 10:45 a.m. at the arbitration center on that day. Respondent, however, failed to file a complaint. So she's only filed the writ of summons and only served the writ of summons. On March 5th, respondent sent an email to Ms. Cleary in which respondent represented to her that she had been notified that the March 6th arbitration hearing was postponed and would be rescheduled because the Philadelphia courts were closed the previous day. The March 6th arbitration hearing had not been postponed. Respondent misrepresented to Ms. Cleary that the March 6th arbitration hearing had been postponed and would be rescheduled. They then failed to appear for the March 6th arbitration hearing. The defendants and counsel for the defendants appeared at the arbitration hearing. With the consent of the defendants and counsel for the defendants, the only people there, the lawsuit was transferred to the Philadelphia Court of Common Pleas and was heard by a judge, who then entered a judgment of non-pros, which means non-prosecution, against the Clearys in the lawsuit. The court noted that a review of the docket showed a complaint had not been filed. So when this happens, when you file a lawsuit or start filing a lawsuit and then you fail to do the things to continue the beginning process of the lawsuit, the defendant can ask a judge to throw it out as not prosecuted. Basically, non-pros means not prosecuted. The plaintiff did not do their basic prosecution of the matter, and so just toss the thing out, judge. On March 9th, the court sent to respondent a notice about the order. Respondent received and reviewed the notice. Respondent failed to take any action in response to the notice, as in, like, calling the court and saying, hey, I screwed up, can we fix this? Or admitting to any of the problems that were caused or anything like that. Respondent failed to advise the Clearys about the entry of the March 6th order, and between March 6th, 2015 and March 2nd, 2016, respondent exchanged the following series of emails with Ms. Cleary. In those emails, respondent represented to Ms. Cleary that the arbitration hearing would be rescheduled, that there was no need for an arbitration hearing because the defendants had agreed to settle, that the settlement was $50,000, and the Clearys would receive that sum as a result of the settlement, that respondent was waiting to receive the settlement check, that respondent was communicating with defendants and the insurance carrier about the delay in receiving the settlement check, that respondent had received the settlement check but a problem arose over how it was made payable, that respondent was waiting for the check to clear before distributing the funds, that the check had been deposited into an account maintained by the Disability Rights Network, that a portion of the settlement proceeds would be used by the Disability Rights Network to mail checks to satisfy outstanding bills the Clearys owned to a high school and a community college, that the issued check had been made payable to a tuition company that processed payments for the high school, that check had been returned, that respondent had arranged for Smart Tuition to receive the tuition payment electronically, that various circumstances arose that result in a delay of issuing the settlement check to the Clearys, that mail delivery problems resulted in a delay receiving the Cleary check, that transportation problems hindered respondent from being able to deliver the Clearys check, that the Clearys would be receiving an additional $5,000 because of the various problems that arose, that respondent had arranged for the Clearys to receive their share of the settlement proceeds by means of a wire transfer. Ms. Cleary made an appointment to meet with respondent finally on March 7th, 2016 to discuss the delay. The March 7th meeting was canceled because of a medical emergency involving respondent's husband. On March 7th, respondent and Ms. Cleary spoke on the telephone. The respondent finally admitted to Ms. Cleary that respondent had not settled the Cleary lawsuit, but it failed to advise Ms. Cleary that the Cleary lawsuit had been dismissed, and the reasons for its dismissal. On March 8th, 2016, Ms. Cleary sent respondent an email asking for an explanation why it was not settled. On March 8th, respondent replied asking for a little more time. On March 9th, Ms. Cleary sent respondent an email and inquired if a malpractice case had been filed on her behalf because she was unable to locate the case. Respondent replied, among other things, stating that respondent would provide her with the docket number when she was back in the office, and claiming that the reason the Cleary lawsuit had not settled was due to a breakdown of discussions when the hospital placed a different lawyer on the same case in a sort of a last-minute move. Ms. Cleary replied, among other things, stating that she was still trying to process everything and the disaster it has left my life in with bills and my son, and inquired if her case was done or if the case was still being negotiated. On March 9th, respondent replied a second time that she would continue to negotiate and she believed there could still be a good outcome. Again, respondent failed to advise Ms. Cleary that the Cleary lawsuit had been dismissed. Respondent misrepresented to Ms. Cleary that it was still possible to negotiate a resolution of the lawsuit that could result in a good outcome. On March 10th, respondent sent an email to Ms. Cleary that contained an email that respondent had received from the First Judicial District confirming that respondent had filed legal paperwork electronically to commence the Cleary lawsuit. Again, respondent failed to advise Ms. Cleary that the lawsuit had been dismissed. During the period that respondent sent Ms. Cleary a series of emails that contained those misrepresentations, respondent also sent several emails to third parties that contained misrepresentations. Wood High School received misrepresentations that DRN had sent payments on several occasions to Smart Tuition. Bucks County Community College received emails that misrepresented that the Clearys were expected to receive settlement proceeds next week. With respect to Smart Tuition, they received misrepresentations that a check had been sent and had been returned, and that additional information was necessary to resend the check. By her conduct, alleged in paragraphs 8 through 51 above, respondent has violated the following rules of professional conduct. And just so you're clear, what we're about to read are the Pennsylvania Rules of Professional Conduct, but these are virtually the same in all states. They do vary a little bit. Some states have slightly different advertising rules or whatever, but these are all based on the Model Rules of Professional Conduct, which law students learn pretty heavily in law school, and all lawyers are required to comply with pretty much at all times. So Rule 1.3 states that a lawyer shall act with reasonable diligence and promptness in representing a client. Rule 1.4a3 states that a lawyer shall keep the client reasonably informed about the status of the matter. 1.4b states that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. Rule 4.1a states that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. And 8.4c states that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So then here's the specific joint recommendation for discipline. And this gets super interesting too. Especially if you remember that we talked about the judge who stole the cocaine, and if you remember why he was disbarred instead of just being disciplined for some shorter period of time, it was because he didn't make a certain showing of evidence of a mental health disorder. Petitioner and respondent jointly recommend the appropriate discipline for respondent's admitted conduct is a suspension for 1 year and 1 day. Respondent hereby consents to that discipline being imposed upon her by the Supreme Court, and attached to this petition is an affidavit stating that she consents. In support, it is respectfully submitted that these are the following several mitigating circumstances. A board-certified psychiatrist prepared a report in which the respondent was diagnosed with complex post-traumatic stress disorder, a condition that results from chronic or long-term exposure to emotional trauma over which a victim has little or no control and from which there is little or no hope of escape. Another psychiatrist has stated that she has been compliant, respondent has been compliant with treatment recommendations and their prescribed medications. The court agrees that respondent has established that there is a causal connection between her misconduct and the mental health condition, which satisfies the Braun conditions that you might remember from the previous video. Respondent has admitted engaging in the misconduct. Respondent has cooperated with petitioner, as evidenced by respondent's admissions and consent to receiving a suspension, and respondent is remorseful and understands that she should be disciplined, as evidenced by her consent to receiving the joint discipline. One aggravating factor is respondent's record of discipline consisting of a private reprimand with a 1-year period of probation for having violated similar rules. In that reprimand, respondent failed to diligently pursue an employment discrimination and wrongful termination case on behalf of a client, failed to provide the client and the client's relatives with accurate information when they inquired about the client's legal matter, and to provide the client with information that she needed to make an informed decision, made multiple misrepresentations to the client and the son-in-law regarding the case. The conditions required her to continue to take prescribed medication, undergo counseling, and file quarterly reports from her therapist. The sanction recommendation relied on another report by her doctor. In that report, the doctor had concluded that when she had engaged in the misconduct, she was suffering from a major depressive disorder. Significantly, respondent's misconduct in the current matter involving the Clearys overlapped with the aforementioned 1-year probationary period served by respondent. Then they go over a case, the Office of Disciplinary Counsel versus Mark D. Colazzo, in which a joint petition, support of discipline on consent, recommended a suspension of 1 year and 1 day for having failed to timely advise a client in a lawsuit in federal court that it had been dismissed on statute of limitations grounds. So that's super interesting. And the reason I wanted to bring that up to you today, besides the fact that that's super interesting, was that this is generally a good idea for life. If you must eat crow, if you have screwed up, eat that crow while it is young and tender, or surely you will eat it while it is old and tough. And trust me, she would be going through a lot less of a hassle if she had admitted these things way back in the beginning. In fact, she probably could have undone some of the damage if she had said, I missed the court date, I screwed up, judge, please dismiss us without prejudice, or give us a chance to refile or something, or sanction me or whatever. but now she probably owes $55,000+ or something to these people, or is facing a lawsuit of about that size or something. So that's just terrible. I can't imagine just going that far with a lie to a client. However, as a person who has faced depression and PTSD, I can say that they do have that effect. And my recommendation to anyone suffering from PTSD or depression is to be very careful not to overload yourself. You have to take time for your healing. You must take time for self-care, as they say. If she has complex PTSD and another major depressive disorder, or maybe those are both the same diagnosis, I don't know. Either way, they're along the same lines. If she is going through that, she super needs to limit how much work she takes and how much she subjects herself to. This is a kind of awakening thing that what's happening in America. If the rest of the world, if you're not familiar with this, our country doesn't really recognize PTSD and depression as super good causes for limiting work or not working or recovering or whatever. We often, citizens, society, whatever, often stigmatizes it and calls people either lazy or dumb or something because they don't just snap out of their depression. Why can't you just be happy? I've literally had friends say to me, just cheer up, just put on a happy face. And yes, that is good advice for some things that are not major depressive disorders. Yes, sometimes people are concentrating on bad things, and simply by not concentrating on bad things, you can make your life better. These are the parables of the two wolves. These are the parables of the two monks. Why are you still carrying her? I put her down miles ago. Which wolf wins? The one you feed. Though these are great parables, but these do not overcome an actual mental health disorder. A mental health disorder of that magnitude is akin to breaking a major bone in your body, or possibly even several major bones in your body. And no citizen would see a person with a broken leg and wonder why they're not winning races. But a lot of citizens will see a person with a major depressive disorder, and instead of trying to understand why a person is not operating at 100%, they assume that they're lazy. Even people who eventually find out that a person has a major depressive disorder still sometimes go and say, well, just snap out of it, or you just, pour yourself into your work. That will make everything easier. Major depressive disorders don't make you lazy. They make you non-functional, which are two completely different things. So my heart goes out to this person, this attorney, because although she's definitely not supposed to be perpetuating those lies, of course, that's terrible. And I hope that her client is able to recover something from either the circumstances of the case and a judge may be allowing things to be reopened, or maybe she can go after this person's insurance if they carry it. Not every attorney has to carry insurance. So I was saying something before about Eat the Crow While the Crow is Young and Tender. Here is the book, How to Start and Build a Law Practice by Jay Foonberg. And of course, you're also welcome to get that or any other book as an audio book at audibletrial.com/lawfulmasses. So that's our show today, everyone. Thank you so much for joining me. You can support more videos, of course, at patreon.com/ljfrench and through one of our many other methods of support that I'm not listing all at one time here. Thank you very much to our March supporters and sponsors. There are a bunch of you supporting at the $50 plus level. DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Vera Mintain, and Sean McNamara. And there are some new $50 plus supporters that I will begin naming on the 1st. I don't have you in front of me right now. And thank you to the 200 plus $5 supporters, $5 plus supporters, who will be scrolling on the screen when we do the video on demand of this. And I'm very, very grateful for all of you. It literally takes this whole 30 seconds of speech or whatever for that thing to scroll by. That's how many of you there are, and it's growing. So You really, I'm really super impressed and super happy. You've given me the space that I need to make more of these videos, to get better at this over time, increase production value, and increase the variety of stories that we can bring to you. So thank you very much for that. This has been an absolute dream come true. I am, of course, Leonard French, your favorite copyright attorney.